Okay, let's get caught up with some of these WSU civil suit documents.
Kohberger allegedly stalked one of the victims. That's false. You knew that was false. For anybody who had never heard that before, that question is now planted into them, unqualified representation that Mr. Kohberger stalked one of the witnesses, and that's false. We do not have evidence that the defendant had direct contact with 1122 or with residents of 1122. But we can put his phone in that area. There are many residences in that area. It's a dense population of mostly college-related occupants.
Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Hey guys, this is Jules. The last video that we did on this subject, on the civil suit that is being filed against WSU, where Bryan Kohberger was a teaching assistant and a student, was an argument based on just the lawsuit itself. It's the one where they just repeated the fact that they had no knowledge or not enough information in order to actually respond to certain things, and it was just extremely repetitive. I'll have a link for the playlist I created for this specific court situation down in the description box. Now, the next set that we're going to be going over is still portions of the venue change situation. Now, there's two things going on right now. There's an argument for the lawsuit itself to be completely dismissed, and there's also an argument in order for this to be moved to federal court. Both of those have been filed by WSU. The plaintiffs say that it needs to stay where it is. This is the one where I told you guys it sort of sounds like if this moves to a federal court, then the rights of the ability to actually have certain things be, I guess, fileable goes away. Again, I just sort of skimmed through it. This is going to be the first time because, again, first and foremost, this is a reaction channel. So we react to things in real time and then we deep dive into the details after the fact. Plus, you know, I do have a real life outside of these YouTube streets. Now, again, these are coming from, I want to say thank you to Sarah, who's putting these over on Twitter in order for us to grab the actual files from the Google Drive. Now, there were two different things that were filed here from the plaintiff's side. This is the declaration of Thomas B. Vertettis, and this is their actual response. And again, this was filed back on February 20th, 2026. The plaintiffs are parents of 4 children who were murdered on November 13th, 2022 in Moscow, Idaho. Plaintiffs filed this case in Skagit, or is it Skagit? Skagit. I've had people say it a couple different ways to me, so I'm just going to go with Skagit County Superior Court, and the state removed the case to the Western District of Washington. The state's motion seeks transfer to the Eastern District of Washington, but this court should deny that motion for multiple reasons. The state's motion ignores key facts and legal principles, and it fails to make the strong showing necessary to justify transfer to the Eastern District. One critical principle that the state ignores is sovereign immunity. The Eastern District was not a district where this case might have been brought at the time of filing. The state has not waived its sovereign immunity for state law claims brought in federal court. So plaintiffs' claims for negligence, gross negligence, outrage, wrongful death, and survival would have been dead on arrival if filed in the Eastern District or in any other federal court. See what I mean? So I was right, sort of. Okay, so far. They are viable now because the state has waived its immunity by removing this action. But the question of whether the Eastern District was an available forum is determined based on the time of filing, and it was not. The court can and should deny the state's motion on that basis alone. So even now, if it does end up getting moved over there, this is going to be null and void. All of this for nothing. But the state has also failed to make the strong showing necessary to overcome the plaintiff's choice of forum based on convenience factors and the interest of justice. First, contrary to the state's argument, plaintiffs effectively chose this forum. Plaintiffs could not have filed directly into the district due to sovereign immunity, but plaintiffs chose a Western Washington forum, and by their choice of claims, plaintiffs opened the door to removal to this court. Plaintiffs filed in Skagit County, home of plaintiff Stacy Chapin, and raised a federal question, their claim under Title IX. Plaintiffs recognized that the state might have removed the case, and plaintiffs embraced the Western District as a potential and appropriate forum. Second, the convenience factors. Considered by courts, and particularly the interest of justice, counsel strongly against upsetting that choice. The state seeks to move this case to the Eastern District when A, plaintiffs chose to be in Western Washington for important reasons discussed further below, B, plaintiffs Chapin and her family live in the Western District and no plaintiff lives in the Eastern District, and C, the true party of interest on the defense side, the state, is based in the Western District. And D, how many are there? Okay, there's multiple. D, both sides have attorneys based in the Western District and neither side has attorneys based in the Eastern District. E, the witnesses are scattered. There are important witnesses in the Eastern District, the Western District, Idaho, Pennsylvania, and in several other states. And overall, there are considerably more witnesses are located, that sentence is written incorrectly, outside of the Eastern District that within it, F, statistics show the Western District to be more efficient based on the time from filing to disposition. G, the publicity is likely to be far more intense in the Eastern District as it has been virtually nonstop since the time of the murders. I don't think that's going to matter, babes. Let's just quit pretending that that even matters here. And H, picking an impartial jury would be far more feasible in the Western District than in the Eastern District, given the substantial amount of information people in the Eastern District have been given about the murders, the plaintiffs' families, and about the role of WSU, which is a major employer in that region. Now, the fact that WSU is a major employer in that region, whatever region they don't have a big financial hold on, is where this should be moved. All of the rest of this is just nonsense to me. This case is known worldwide, and if there really is life outside of this, whatever this is, they damn well know about this freaking case too, okay? There is nothing that they need to be trying to argue when it comes to, oh, there's going to be less rumors and less people knowing stuff over here. No, we're not playing that game anymore. The only thing that is even mattering right here is this. Wherever there is not a financial hold on the actual jury people is where this needs to be held. That's the only important thing I see. The last point goes to the interest of justice, which is always a critical consideration in litigation. The Seattle division has nearly 4 times the population of the Spokane division, and the residents of this area are less likely to have heard as much about the murders and potentially formed opinions about the parties and issues involved. Therefore, and through no fault of the residents of the Eastern District, the chances of picking an impartial jury are far better in this court, and the interest of justice counsels against transfer. For these reasons and those explained below, this court should deny the state's motion transfer. Evidence relied upon: the declaration of Thomas B. Fertettis, as well as the existing file on record in this matter. So now we're going to go over here and we're going to go through this before we continue on with the document. Declaration. I, Thomas B. Fertettis, declare that I am an attorney who has entered an appearance in this proceeding. I have personal knowledge of the matters contained in this declaration, and if called upon as a witness, could and would testify here too. Now, as you can see, this person right here, notice the name, okay, is this. He is one of the attorneys at the law firm for the plaintiffs. His name is literally in the letterhead. And it looks like this does have some information about how this area actually employs 30% of that county. Damn, that's crazy. It says, attached to this declaration as Exhibit A is a true and accurate copy of a March 2022 document from Whitman County, Washington, indicating that Washington State University employs 30% of the workforce in that county. Damn, that does matter. That matters so much. When filing this case, we could not have filed in any federal court, as all of our state law claims would have been subject to sovereign immunity. Some of our clients also preferred to be as far away from the traumatic event that led to this case as possible. Based on our research, we determined that possible filing locations included Skagit County Superior Court, Thurston County Superior Court, and Whitman County Superior Court. We chose to file in the county where plaintiff Stacy Chapin and her family live, which is Skagit County. Plaintiff's counsel, including myself, understood that by including a federal claim under Title IX, we were filing a case that was undoubtedly removable. We determined that we had no problem proceeding in federal court if that was the defendant's choice. The interest in the underlying murders has been so substantial that various government entities in that area have web pages devoted to providing information about the murders. This is true. These include the Idaho State Police, the Latell County Idaho Sheriff's Office, the City of Moscow, and the City of Pullman. Yes, and I have links to every single one of those official sources down in the description box of not just this video, but every single video on this case has links to all of the resources. As required by law, plaintiffs submitted a pre-filing notice to the state for each of the 4 plaintiffs. Included in those documents were lists of witnesses. Plaintiffs' team has researched the location of those witnesses, and we have tabulated their locations with relation to the federal districts involved. Of the 69 witnesses named in these documents, 32, less than half, reside in the Eastern District of Washington, and 37 reside elsewhere, including 14 who reside in the Western District of Washington. I said, even though I don't believe WSU is liable for anything here, the biggest problem I have with this, besides my own opinion on this case and how nothing sits right, and I don't believe we have the truth, and I don't believe we've got the right guy, and the fact that the evidence is so lacking, and the state themselves can say stuff like this in a freaking plea hearing.
We do not have evidence that the defendant had direct contact with 1122 or with residents of 1122. But we can put his phone in that area. There are many residences in that area. It's a dense population of mostly college-related occupants.
I have no reason to believe this story. And even if I didn't have the actual physical evidence, we have what the state has said. And if we didn't have what the state said, they still had no answers to any questions on top of the actual documentation from forensic labs and evidence that we have been able to see ourselves. None of this matches up. And when the lead prosecutor can stand up in court and say this,
Kohberger allegedly stalked one of the victims. That's false. You knew that was false. For anybody who had never heard that before, that question is now planted into them, unqualified representation that Mr. Kohberger stalked one of the witnesses, and that's false.
And then we see that the lawsuit against WSU is all about stalking when we already know that wasn't a case here. How can I take anything in this entire thing seriously? I cannot be on board with this. And even if I was a guilter, as we've suddenly all had labels since this case happened, I would not be able to say that I agree with this lawsuit because of all the false allegations in it. There's so many lies in that lawsuit that was filed against WSU. And if you want to actually get into the details of that, it looks like this. And again, it's in the playlist, which again, will be in the description box below. But with that all being said, I've still said that I want this to go to court. I want to be able to get depositions. I want to see interviews. I want to get the true information here, because the main problem I've had with all of this is the origin story of how all of these so-say formal complaints started being filed. And we've all heard it. We've all heard it, and that's not going to be discussed in this video because I'm really trying to stay to theme, but there's just so much bullshittery in this case. You literally cannot help but go off of the rails in a different direction at any given time, because eventually it all circles right back around to it. And I'm saying all of that to say this too. All of these people, or at least a majority of these people that we know are going to be on this witness list, that are part of these so-say formal filings, that are people that were at WSU, that are family members, that are friends, that are people that heard things, professors, police officers, all of those things. All of those people that had issues with Kohberger after his name was named publicly, not a single one of those people ever turned him in as a tip. Not even the ones who were in the same vehicle with him that he drove around. None of them ever thought, hey, he could be the guy. His car matches. He's a bit weird. He makes everybody uncomfortable. All of these people in these criminology, big titled, career paths, and none of them turned him in. And let's not forget that the professor that he had the most problems with said that if WSU were to let Kohberger go, it would end up in some sort of civil suit because they had no stance to remove him. All things that people need to keep in mind here. Many of the witnesses listed in the aforementioned form were graduate students at WSU who reported problematic interactions with Kohberger. But now, more than 3 years after the murders, they have finished their coursework and have moved away from WSU. 7 of these former graduate students now reside in the Western District, while others reside in Arizona, California, Hawaii, Missouri, North Carolina, and Oregon. Based on plaintiff's investigation to date, there are at least 9 additional witnesses in Pennsylvania, including Kohberger's family, mother, father, and sister. I wonder if they mean just one or if they plan on maybe talking to both and just forgot the S. A school administrator that removed Kohberger from a trade school program due to complaints from female students, Kohberger's criminology professor at DeSales University, at least 2 female employees of a local business that raised concerns about Kohberger's behavior, and 2 forensic examiners that examined Kohberger's devices after the murders. So that would definitely be something considered discovery for the crime. So yeah, they really do need to just let this case happen and let us have some damn discovery already. Because these are things that we've been literally begging for proof of, and they've been claiming that they couldn't give it to us because it falls under some sort of privacy thing because it's education related, it's school related. Your educational information is protected like that, the same way that it is under HIPAA when it comes to your medical information. So if they could actually release some of this, that would be superb. I really, really, really want to know what things were being filed against him before his name was announced publicly as the person arrested for the crimes, because the story is always so much different before there's a tone that has to be set. You all know that. Plaintiff's team has researched available flights between Philadelphia, the closest major city to where Bryan Kohberger lived in Pennsylvania. Why do they continuously spell his name wrong? And both Seattle and Spokane. 3 airlines have or will have nonstop flights between Seattle and Philadelphia, American, Delta, and Alaska. So this is like the logistics, I guess. Delta's service is scheduled to begin in May. It appears that no airline has or plans to have nonstop service from Philadelphia to Spokane. Plaintiffs have already retained a team of experts in the state of Georgia, and plaintiffs intend to retain several additional expert witnesses, many or all of whom likely will not live in Washington. Probably not. Plaintiffs plan for all retained experts to testify live at trial. Plaintiffs will commit to deposing in Pullman, Washington, all fact witnesses who are based in Pullman. Some of plaintiffs' attorneys are based in Kansas City, Missouri. There are non-stop flights to Seattle from Kansas City on Alaska Airlines and Delta. There are no non-stop flights from Kansas City to Spokane. So it's not only going to cost extra money because you're going to have to get rental cars and drive the additional way, but because you have to get into a vehicle and drive the additional way, it's also going to take hella extra time and hella extra stress. Damn. Yeah, I can understand exactly because Plaintiff's team has researched the time to outcome in both of the Western District of Washington and the Eastern District of Washington using Westlaw litigation analytics. At the time of that search, the results were 174 days in the Western District, 244 days in the Eastern District. Dang. And then this is just Exhibit A, which is the profile itself that just talks about the area in general, the land area, the geographical facts, the outlook. It's basically just something that would come from like a government website. Gives you the median income, the population, demographics, education, different leaks. I mean, it's really nothing too special, literally at all. Okay, let's go back to the actual filing. Legal standard. This court may transfer venue to any other district or division where it might have been brought, if transfer would serve the convenience of the parties and the interest of justice. The moving party has the burden to show transfer is warranted. Argument. This court should deny the state's motion because the Eastern District is not a district where this case might have been brought, and because the convenience factors in the interest of justice do not support transferring this case to Spokane. Because the state is entitled to sovereign immunity in federal court, this is not an action that might have been brought in the Eastern District. The first reason that this court should deny the state's motion is that the Eastern District was not a forum where this case might have been brought due to sovereign immunity. No federal court was. The state largely ignores this issue, asserting only that venue is proper in the Eastern District of Washington because the alleged acts in the complaint occurred in Pullman, Washington, and Moscow, Idaho. But the question is not whether the action could be transferred now. It is whether the action could have been originally brought in the Eastern District. Due to sovereign immunity, plaintiff's case could not have been brought in any federal court. In citing Phillips Petroleum Company versus the Federal Energy Administration from 1977, holding that transfer is appropriate only if the plaintiffs had an unqualified right to bring the actions in the transferee forum at the time of the commencement of the actions. The state has waived sovereign immunity for tort claims brought in state court. However, the 11th Amendment bars citizens from suing their own state and federal government. And in this citation, it says, although the state of Washington does permit tort actions against it in Washington state courts under the provisions of RCW 492010 and 090, it has not waived its 11th Amendment immunity to suits against it in federal court. This doctrine applies to cases against WSU because WSU is an arm of the state of Washington and the state is therefore the true party in interest. However, by removing the case to this court, the state consented to federal jurisdiction and thereby waived sovereign immunity. Embry versus King from 2004 cites holding that removal is a form of voluntary invocation of a federal court's jurisdiction sufficient to waive the state's otherwise valid objection to litigation of a matter in a federal forum. All of plaintiffs' state law claims would have been dead on arrival if plaintiffs had filed in the Eastern District. This includes underlying claims for negligence, gross negligence, and outrage, as well as the wrongful death and survival claims that allow the plaintiffs to be plaintiffs. The Ninth Circuit has treated a sovereign immunity issue as one of subject matter jurisdiction. This district has labeled sovereign immunity as quasi-jurisdictional. In a recent case with many similarities, a party sought to transfer a case with both state and federal claims to another district in the same state, after that case had been removed. That court denied transfer, holding that due to sovereign immunity, the plaintiff's state law claims could not have been brought in the proposed transferee venue. The circumstances here are similar. The Johnson court denied transfer, where the 11th Amendment would have barred the plaintiff's claim against a defendant in the proposed transferee court. The plaintiff filed his case in state court, asserting a state law claim against the West Virginia University Board of Governors and a mix of federal and state law claims against other defendants. The defendants removed the case to federal court because, as here, one of the plaintiff's claims arose under a federal statute. The plaintiffs then sought to transfer venue from the Southern District of West Virginia to the Northern District of West Virginia. The defendants, the parties contesting transfer in that case, again, they're talking about one in West Virginia, not this one, they're using it as an example, argued that the action could not have been brought in the Northern District because, as an arm of the state, the West Virginia University organization had 11th Amendment immunity for the state law medical malpractice claim. The court agreed and denied the motion to transfer. Thus, under Johnson, the fact that a plaintiff could not have brought this full case in the proposed transferee venue prohibited transfer to that district. The same logic should apply here. Even if the plaintiffs could have brought a Title IX claim in the Eastern District, the overwhelming majority of their claims were barred by sovereign immunity. Therefore, it was not a forum where this case, with 6 claims, 5 of which arose under state law, might have been brought. Because plaintiffs could not have brought their claims in the Eastern District, transfer would be improper. The next one says, the convenience factors, the interest of justice, and the public interest factors do not overcome deference given to a plaintiff's choice of forum, and in fact, many of these factors support denying the motion of transfer. The second reason this court should deny transfer under 28 U.S.C. is that considerations of convenience and fairness counsel against upsetting the plaintiff's choice of forum. As this court has written, under 1404A, great weight is generally accorded plaintiff's choice of forum. To upset the plaintiff's choice of forum, a defendant must make a strong showing of inconvenience. That's pretty much what the exhibit did do. So they're going to also probably end up repeating some of the things we've already read. The state's brief focuses on the factors laid out in Jones, and plaintiffs will explain how those factors on balance support denying transfer. These factors are often referred to as convenience factors. The Jones factors do not represent the entire analysis. Again, the ultimate inquiry is whether the proposed transfer is for the convenience of parties and witnesses and in the interest of justice. Here, the interest of justice strongly supports denying the transfer. The murders at issue have brought intense media scrutiny, particularly on the eastern side of this state. Litigating in this court would give victims' families some protection from that intense media coverage and would serve the interest of justice by increasing the likelihood of picking a truly impartial jury. We're still not going to pretend like anywhere is going to matter when it comes to that subject. Plaintiffs effectively chose this forum, and the convenience factors support maintaining this case in the court. Plaintiffs agree with the state that the first two convenience factors are inapplicable to this case, but the state is incorrect that the third factor, the plaintiff's choice of forum, is inapplicable here. Plaintiffs will analyze the remaining factors beginning with that one. Plaintiff's choice of forum. Again, a plaintiff's choice of forum is entitled to substantial deference. That is particularly true where, as here, a plaintiff lives within the chosen forum. The state claims that plaintiffs did not choose this forum because they did not file the case here, but in the unique circumstances of this case, the state's argument places form over substance. As explained in Section 1, supra, the plaintiffs could not have filed in any federal court as the state would have been immune from their state law claims, negligence, gross negligence, outrage, survival, and wrongful death. So plaintiffs had to file in the state court. Again, they wouldn't have a case, I guess, at all if it went federal first. Plaintiffs likely had three options. Again, they repeat this stuff over again. Let me go down some. I don't want to just keep reading the same stuff over and over again. It gets really old. Yeah, they're just repeating again how this is where the Chapins live. So that gives it, more probability or more leverage to be there. The Eastern District was home to the man who murdered plaintiff's children at the time of the murders, meaning this is where Kohberger also lived. It is mere miles from the location where those four murders took place. It is a region where the killer's school and employer, WSU, is a major employer and has a massive presence. This is the only thing that matters to me. And it is in an area where interest in these murders and the resulting media scrutiny has been extremely intense. And again, it's going to be like that no matter where. I don't care. No matter where it goes, everything will follow. They know this already. This is like duh. Thus, while plaintiffs did not literally file in this court, they understood that they were on a path to this court, and they had a strong preference for remaining here. WSU is an arm of the state. Yeah, they already said that too. And this is where they talk about transfer. And again, we heard what was said in the exhibit, so there's really no reason to continue to keep going. Now, down at number 3, it says contacts related to the cause of action. The fifth convenience factor, the contacts related to the cause of action, generally turns on the location of witnesses. There's people there locally, there's people in other parts of the country, and here they've actually broken them down. And I know that Kohberger's name himself being on here is piquing a lot of people's, interest, but just because they have him listed as a potential witness for this case itself doesn't mean he's going to speak. I don't think they can force him. I mean, if they are refusing to even try to get any sort of real true answers out of him, because they know they actually can't because he's got none, in my opinion, then I don't know what this is going to do. But hey, if he comes out here and he speaks during this situation, it's definitely going to be interesting. But let's go ahead and see the little itemized, vague yet itemized list they gave us here. 4 members of the Chapin family, 6 members of the Goncalves family, 2 members of the Kernodle family, 2 members of the Laramie family, 2 coroners, 19 members of the WSU faculty or staff, and 33 of Kohberger's fellow graduate students and or teaching assistants, and Kohberger himself. Of these 69 witnesses identified on this list, plaintiffs provided to the state in November of 2025. 32 reside in the Eastern District and 37 reside outside of the Eastern District, including 14 in the Western. And as plaintiffs' investigation has continued, the number of fact witnesses outside of Eastern District has grown substantially. Plaintiffs expect to depose numerous witnesses in Pennsylvania, which is where Kohberger lived before WSU brought him to the Moscow Pullman community. Plaintiffs will need these witnesses to show that WSU should never have hired Kohberger due to prior red flags. These red flags based in Pennsylvania include, but are not limited to, his H addiction, which is interesting because a lot of the stuff when it came to things that happened, like the arrest for theft for taking and selling his sister's phone, they didn't even want to mention that at trial. That stuff was literally being removed. The state was okay with not bringing up prior acts. It was very strange. This whole freaking thing is just so not normal. His H addiction, complaints from female classmates, an arrest for theft, a fascination with serial killers, and local businesses taking special measures to alert staff when Kohberger was present. Now, I mentioned this before. We had a bar and a guy from a bar that came out with a story. And when other news sources, when people from other organizations started reaching out and asking for proof, show us what it looks like in the digital system. You say you had a note somewhere to warn people. You said it was some sort of alert, something. When he came in, there was a note somewhere that staff would be alerted. Do you have that? Can you produce that? None of that was ever shown to anyone. So these are just people speaking. They're just people telling stories that have no actual proof of anything, meaning no actual factual proof that who they're talking about was actually Bryan Kohberger, because they are not showing anyone anything in the system that says his name and his ID, his face, his person was actually flagged. And that's all that we're asking for here. That's nothing to ask for, is the physical proof. And none of them have produced it. So again, I really want this to go through. I want to see this stuff. Based on plaintiff's investigation to date, there are at least 9 additional witnesses in Pennsylvania, including Kohberger's family, mother, father, sister. And again, they do it with singular, not plural, a school administrator that removed Kohberger from a trade school program due to complaints from female students, Kohberger's criminology professor at DeSales University, at least 2 female employees of a local business that raised concerns about Kohberger's behavior, and notice this says Pennsylvania-based, and then 2 forensic examiners that examined Kohberger's devices after the murders. Now, I'm going to assume this would be the Celebrite people, but we already know how much of a joke they are, and they have not released their analytical reports. They have come out here and given interviews and talked like little 8th graders and been little gossipy chatties and nosy little Nancys, but they've literally done nothing but give us information that leads to nothing, along with a bunch of selfies that nobody asked for. And let me also remind you that I reached out to Celebrite myself. This is what it looks like. I'll have a link for it down in the description box. And they sent me a link, which was their Google Drive of information. I also have that on the Google Drive for the case that I have put together for the channel. And when I reached back out and asked if they had other photos besides these selfies, because again, I don't care about these selfies. The only selfie that matters to me is the one that was taken that morning. That's the only one that matters, which again had 3 different versions out there. We, the public, had 3 different versions of this photo put in our faces. That's just side note. But when I reached out and asked if they had anything else, I never got a response. And we know that the Dateline episode that's supposed to be a leak investigation now had other photos that they're claiming also came from Kohberger's phone. Ones of his car, ones of other things. That's what I wanted from Celebrite. And again, they never responded after sending out nothing but selfies and information that didn't prove shit. Thus, at least 46 potential fact witnesses reside outside of the Eastern District, and plaintiffs expect to uncover more as their investigation continues. Many of the known fact witnesses were graduate students at WSU who reported problematic interactions with Kohberger. Now, more than 3 years after the murders, most have finished their coursework and moved away from WSU. And they just repeat again that they're basically everywhere, including Hawaii. And now they're getting into the costs of litigation, but let's also be so serious. They don't really care. I know it's talking about like airplane tickets and other things and things that's going to cost money to get people here and there and everywhere else and lodging and blah, blah, blah. But again, at the end of the day, that doesn't even matter. They're going to do whatever they want to do. Now, this is interesting. So this one is called Ease of Access to Sources of Proof. Plaintiffs do not contest the state's assertion that service of process issues are neutral, but they do not contest the state's position on the 8th and final Jones factor, ease of access to evidence. This factor is neutral because the documentary evidence will almost surely be produced electronically. But isn't that also true for all of these witnesses that they're trying to say all this matters for when it comes to logistics and moving them around and getting them there? All of this stuff can literally be done through a Zoom meeting. All of it can be done through a live internet session. People do not need to physically show up to these things anymore. They really need to get with it. And this one is talking about being able to seat an impartial jury. And I'm honestly not even going to read it because it doesn't matter. This case is known across the planet. This is going to be followed no matter where it ends up going. All of this to me is completely irrelevant, and I'm not going to waste my time or you guys' time reading this because we already know. We already know. No matter where this goes, the frenzy is going to follow it. So none of it matters. When it comes to public interest factors, it says the state also briefly argues certain public interest factors, but none of them support transfer in this case. And an additional factor is identified by this court supports denying transfer. On balance, then, those factors offer no help to the state's motion. Administrative difficulties. The state simply repeats its argument about certain events taking place in Pullman and certain witnesses being located there. These issues are addressed above. Yeah, same stuff. And when it comes to jury duty, it says the state claims that subjecting jurors in the Western District to jury duty is unnecessary. But as explained above, it is absolutely necessary to ensure an impartial jury. Further, the suggestion that the people of Western Washington have no interest in a case involving a major public university with 2 campuses in the district, bringing a mass murderer into the state defies credulity. As residents and taxpayers, everyone in Washington has an interest in the state's activities and its employees, such as Kohberger, but this case goes far beyond that basic interest. It seems unlikely that any juror seated in this court would find the case to be irrelevant, literally no matter where in the state. No matter where. Now, this is talking about bringing a dangerous individual into the state. Well, I can tell you this right now. Even if he somehow is some sort of megalomaniac killer who literally had left not a single really true trail, but a little minuscule, sneezable dust particle wannabe of a touch DNA speck on who knows what Q-tip because the swab was resubmitted and they're not telling us the truth about literally anything whatsoever. That state has so many issues. I promise you there's more dangerous people already living in that area. And if you really want to get so for real when it comes to the way that I don't know, maybe some of these family members have actually done things. And let's also not forget how dangerous and how many convicts and how many horrible fraudsters claim to be streamers and content creators that also go to these places when stuff like this starts happening and it's a new hot trending topic. So I wouldn't be too worried if the guy that has to be shackled at the wrists and the legs and has to be under heavy security has to come in and testify. There's a lot worse people out there walking them streets. This next one is average time to disposition. A final public interest feature noted by this court in Hutto is court congestion. This court found the issue difficult to determine because neither party presents statistics on the median time from filing to disposition in this district or the District of New Jersey. And again, they're just quoting stuff from other cases. In the Western District, the median time to outcome for torts and negligence cases is 174 days. So again, they're just repeating what we've already read, that it's going to take a lot longer if this gets put in the Eastern District for this to be finalized than it would if we were in the Western. And they're saying again that the public interest factors here just do not support the state's motion whatsoever. Conclusion. For all of the foregoing reasons, this court should deny the state's motion to transfer venue. The Eastern District was not an available forum at the time of filing. The convenience factors do not support transfer. The interest of justice cuts strongly against transfer, and the public interest factors also do not support transfer. On balance, there is nothing to overcome the significant deference given to the plaintiff's choice of forum. Okay, I'm finishing up this editing on March 7th. It's a Saturday. I'll be posting this on March the 8th on Sunday. So this is so far what we know, and there's no decision as of the time that I am going to be posting this. If this is going to be moved to federal court, if this is going to be dismissed, we don't know what the next steps are. But for now, Let me know what you guys are thinking about this lawsuit down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out, subscribe to the channel if you have not subscribed already, and please don't forget to make sure that the notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.